This episode is brought to you by Progressive Insurance. Whether you love true crime or comedy, celebrity interviews or news, you call the shots on what's in your podcast queue. And guess what? Now you can call them on your auto insurance too with the Name Your Price tool from Progressive. It works just the way it sounds. You tell Progressive how much you want to pay for car insurance, and they'll show you coverage options that fit your budget. Get your quote today at Progressive.com to join the over 28 million drivers who trust Progressive. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law.
Welcome to Come Back with a Warrant podcast. I'm Monica Ishak.
And I'm Brandon Dinitz. On today's episode, we'll talk about the reality of domestic violence cases, victims' rights, and the double-edged sword of Marsy's Law, and the plea deal trap.
As always, this podcast is for entertainment and educational purposes only. Nothing you hear today is legal advice. If you need legal help, hire a lawyer. Better yet, hire us.
Welcome back. Another episode of Come Back with a Warrant. Very excited to be here with you.
Yes.
Interestingly enough, today's episode is a topic that I think we're going to get a lot of feedback on. We're talking about domestic violence cases, and I think we're going to be talking about them from a perspective that's different than what people generally think. We're not going to be talking about them in a sense of, well, you know, there's just these people that are accusing people of domestic violence, and either men or women are just accusing people left and right, and it's all BS. No, that's not at all what we're coming at it from. The truth of the matter is that in the state of Florida, if the police are called and it is a domestic incident, somebody is going to jail. And it's not always the intent of the person that's calling 911 to put the other person in jail.
Yeah.
Often it's to diffuse the situation, to make things a little bit, really to bring the temperature down on an argument, or just to scare somebody. And that's not what happens.
Yeah, and the way you worded that, I really like that, because you said when the police are called. Sometimes the person that calls the police
is the one that gets arrested.
Yes.
Yeah, for sure.
It's like, what? I called you guys to come help me, and you guys are taking me with you?
Yeah.
And that happens a lot. And, you know, there's always, on the body-worn camera, I always see the officers, y'all called us, so we had, and you called us, plus domestic, someone's got to go, you know?
Right.
So it's funny because I think, you know, before we get into Marsy's Law, but I really do think it's a double-edged sword because of the way it functions and the avenues it gives certain people, specifically victims or alleged victims in those cases. So we'll get there. But yeah, when you said like when the police are called, I was like, that's so real. Like the way you said it was just so good. So going into the reality of domestic violence, obviously, and I mentioned this before on other episodes where, you know, people, we were talking about like villains and heroes, and people are just always going to feel like it's going to feel a little bit more personal when it comes to domestic violence, versus, you know, another case where it's like a theft case or whatever, you know, or even a regular battery case, because usually those parties don't know each other. But when you get into domestic violence, you're getting into people's shit.
Yeah. No, you are getting into the most personal of their personal life, and it's the worst part of their personal life. And I think we can't make the caveat enough. There are so many legitimate domestic violence calls and claims that happen. And when I say legitimate, I mean that there is an actual abuser, there is an actual victim, and it is warranted for the police to be involved and for there to be some sort of intervention in a bad scenario. That is true. That is out there. But what we see a lot of is a situation where the police are being used just to try to scare somebody else, or you have a person who's not really a victim.
Yeah.
But knows a little bit about the the system and the situation, and is now using the situation to their benefit.
Yeah.
Because I'll give you a perfect example. I've had clients that were professionals.
Yeah.
Okay? I had a client that was a doctor, no prior criminal history, and he and his wife got into an argument. The wife called the police. The wife said that he had pushed her. My client said that nothing had happened, and legitimately just a push. I'm not, exaggerating for the story. Just a push. My client was arrested. Now he has had his license as a doctor called into question.
Yeah.
He has lost clients over this.
Yeah.
And the criminal case is gone.
Yeah.
The criminal case is already dismissed because the wife entered a affidavit of non-prosecution. She didn't want to prosecute. She didn't want this to go as far as it did.
And coming to like speaking about not just physicians, but like even being on the school board, a teacher,
right,
or a nurse, any sort of like if there's a professional board evaluating you or your license or your competency to be able to practice or function in your career, like that is going to be a secondary, and like obviously your freedom's on the line. So if it ends up going away because of the non-prosecution affidavit, which often happens, and then they have to deal with the actual issue, which is like their livelihood, and the wife in your scenario would be benefiting, I'm sure, from his career. So like she's shooting herself in the foot by even engaging in this type of like getting police involved over something like this, because at the end of the day, now he has to deal with maintaining his license if he can. I think the Florida bar is very, like, I think they're pretty reasonable when it comes to attorneys when they get arrested and in trouble, because I think there are some people that have had histories that are able to kind of prove their character and fitness and still become and practice attorneys. But other boards are not as gracious. It's still a hard process. You still have to prove all these things. You still have to show all these things with the Florida bar. But other boards are like, if you have that like, we don't even want to talk to you.
Because you're an accused domestic abuser.
Yeah.
Nobody wants that.
Yeah.
Nobody wants to hire the person that's been charged with domestic violence.
It sounds so much worse than what it is.
It sounds horrible.
Yeah.
Right.
Especially when it comes to like, oh, you're talking about the facts. It's a push versus when you say domestic violence.
Right. If it's a push. And it could be as simple as two people that live together that are married or in a relationship are arguing, and one is like, screw you, I'm getting out of here, I'm leaving the house, and goes to walk past the other one, and the other one doesn't allow them to walk past, and there's physical contact. You have a battery.
Yeah.
Under the legal definition, you have a battery.
Yeah.
And now you have a person that's willing to call the police and bring the police in. You have the elements of a domestic battery. And something we've talked about in this show, and we'll talk about more obviously in this episode when we talk about victims' rights with Marsy's Law, the state attorney's office is now hand-tied because they have obligations under the Constitution. The victims have constitutional rights that the state attorney's office has to listen to and hear from. And when I was at the state attorney's office, Marsy's Law was passed. And for those of you that don't know, Marsy's Law was created to protect victims. And it's a law that allows victims to have a constitutional right to be part of the proceedings and the different stages of a criminal proceeding that they are the victim of. They are able to be involved. They are able to be present. They are supposed to be notified. Their position is supposed to be heard.
Yeah.
That doesn't mean they're supposed to run the case.
Yeah, but...
And oftentimes that's where the problem happens.
Yes.
Because they take the Marsy's Law protections to mean that what they want to have happen in a case happens.
Yeah. When
that
really
means vindictive nature overload.
Yeah. And the purpose of it is really to give them a voice, to have them be heard, to know when, sentencing is, for them to be able to speak at sentencing or whatever it is, but for them to dictate offers, for instance. Like I've had, I think, conversations with prosecutors where it's been like, I have to be able to go to my supervisor and get this approved by them because the alleged victim is not, and that's our office policy, is that we have to go by what the alleged victim said. And like, for me, it's like if the facts are showing otherwise, you know what I mean? Like the photos of the injury, like there's so many that their testimony is not the only thing in the case.
Right.
So sometimes it is, and that's different when it's he said versus she said. And then there's a lack of evidence, argument for the defense if there are no injuries and no other witnesses or whatever it is. But, when it comes to like being able to see that there are other pieces of evidence that kind of disprove what that person is saying and they're still not willing to do it, that's when it becomes a problem, because it is a personal thing for them. It's not just, and most of the, yes, domestic violence can be between like a mom and a son or whatever. It can be between anybody that lives in the same household. Oftentimes it is between couples, and oftentimes it arises out of like whatever situation or drama or issue is going on in their relationship. And that's why I was saying we really do get into their shit, because we don't just talk about like the battery in the trial. We talk about what led up to that. Yeah. Like
the
why
cheating
are you,
and the allegations of everything else, the arguing, the different problems that couples have that is now put on display because it culminated in
and it's
an incident.
It's embarrassing on top of that for them, I'm sure. And like not only that, that's without kids involved. Imagine like with kids involved. And then when kids aren't involved or present during the allegation or the alleged battery, that person who's accused of the battery or the domestic violence, they are not able to be around their children, and then also we cannot ignore the fact that they basically become homeless, even if they have.
That's a big thing.
Huge.
And that's a huge thing that I think people also don't know. When you have a criminal case and there is an alleged victim, oftentimes the courts will order no contact with that alleged victim.
Yeah.
And that's very common at first appearances as part of a bond hearing, that there will be no contact with an alleged victim. Well, what happens in a circumstance where that alleged victim lives in the same house as you? Which
is domestic, the definition
you're
of
out.
Domestic. Yeah.
You are not going home.
Even if you pay for the bills.
And you are under an obligation to continue paying for those bills.
Yep.
You are not allowed to go home. You are now in a position where you have to figure out a place to live pending this criminal case.
Yeah.
And court is basically saying, yeah, I'm kicking you out of your home while this is pending. Whether these allegations are
true
BS or not, you're not going home. That's a really, really scary part, because somebody, again, if you have, and this happens a lot, you have people that are abusing the system.
Yeah.
And they know, if I get this person in trouble and I get a no contact order, that's it. They're out of the house.
Yeah.
They're not coming home. The house is mine. And I have had cases like that where that was what was going on. It was an alleged victim that was just vindictive, and ultimately the charges were dismissed against my client. But there is
so much damage.
There's so much damage that can be done by someone being vindictive that knows a little bit about how the legal system works.
Yeah.
And that's what's scary.
Yeah. And then and throwing kids into the mix, and then the effect it has on the children is like, I think that so many people are operating from a place of like preservation, or like trying to show that they're the victim, or whatever story they want to put out there about themselves, that they literally don't think about the damage they're causing on their shared child or their own children. Like, do you know what you're doing?
Right.
And it really does mess them up. Like, it's not okay. And like sometimes even when they result in, like, going back to what you were saying, because you were saying there are real victims, yes, but the real victims don't make up most of these cases or the system.
No, not at all.
And it's
unfortunately, that's not who's dealing with it. Or they're in the more serious situations, the felony domestic cases. Sometimes have the victims are far more, I don't want to say legitimate, but they have a much more obvious case where they are the victim. In the more serious cases.
I think it's clear when I get one where it's like, okay, I think we need to take a plea. Like, you should not entertain this for trial, but then other times domestics, I'm like, let's go to run it. Let's go.
Of course. And I in addition to representing defendants in criminal cases, I do victims representation in cases also.
Same.
So I've represented victims in domestic cases that were very much victims of domestic abuse. And the reason that Marsy's Law exists, and the reason that these rules are in place, and the reason that police do make the arrests are for situations like that.
Yeah.
And it does exist, but the concern is there's people that abuse the system,
Yeah.
and they are able to do so successfully.
Yeah, and the fact that I think that judges and prosecutors entertain these false claims that are very obviously false, it takes away from the reality of domestic violence. Because when we're practicing attorneys and 90% of the domestic violence calls I get, I'm like, oh, okay, like most likely either this is going to be a trial or a stand your ground. Like I'm most likely either I'm very confident when I get a domestic violence case. Obviously, I have to see the evidence that I could probably get it dismissed if they have no criminal history, you know? But if it's something that they like, there's evidence to show like they're really bad injuries. Like sometimes the injuries are bad, and I'm like, listen, there needs to be some explanation as to what happened here. So tell me if there's a stand your ground or not, because that's going to be, it's either it didn't happen or you were defending yourself. Which one are we going to do, you know? But it really does, it's insulting to real like domestic violence victims. So I think it's not fair at the end of the day when they entertain that. So like, it's just, it's really.
Hi, it's Daniel from John Buys Bay Area Houses. Is your house more trouble than it's worth, dealing with endless repairs, frustrating tenants, or an inherited property that's just sitting there? You're not alone. A lot of homeowners feel stuck, not knowing where to start. That's where we come in. At John Buys Bay Area Houses, we make selling your house simple. Just call 510-800-JOHN or visit our website and you'll get a fair cash offer in minutes. We buy houses as is. That means no cleaning, no repairs, no agent fees or commissions. You choose your timeline, you skip the hassle. We handle the hard part so you can move on with confidence. Start fresh. Don't let your house hold you back. Call 510-800-JOHN or search online for John Buys Bay Area Houses to get your cash offer today. That's 510-800-JOHN.
Start fresh with John Buys Bay Area Houses.
Unfortunate to see the system flooded with so many false claims, and like so many times it's like they're treated like they're true victims. And I'm like, I really do feel like, obviously I've never had a prosecutor tell me like, oh, I don't think they're a real victim. Like they would never say that. But I'm like, do you really believe this shit happened? You know what I mean? Like, do you really believe that just because this person is saying that? You know, they have so many reasons to lie. And
Well,
like none
yeah.
of that comes into play.
I think domestic violence prosecutors are generally afraid of the victim and of the judge.
Yeah.
I think certainly younger ones, older
Yeah.
ones that have a little bit more discretion
They're better.
or that file their own cases, maybe it's a little bit different. But the younger prosecutors in domestic courtrooms are basically
A pawn.
scared to do anything other than blanketly trust what a victim is saying, and in front of the judge think that what that judge wants is just for them to be as harsh as possible and prosecute as hard as possible. And I see that oftentimes in the domestic courtroom.
Yeah.
It's that, you know, and this is not a shot against domestic violence prosecutors or
No.
the domestic violence judge or anything else like that, because again, they are responsible for sifting through these claims. And I think when you see them getting taken advantage of, it's, you know, unfortunate, because there's just so many of these false claims out there that you have prosecutors that are believing
Lies.
either believing lies or not willing to take a step back and look at the helicopter
Yes.
view of the case
You
and
have to
say,
zoom
does this
out.
really make sense?
Yeah. Because what's going to happen is we're going to set it for trial.
Right.
And then you're going to have to realize that the hard way, and after putting everybody through all
Right.
of this. But again, like you were saying previously, the judges don't always help. And especially when it comes to DV, I think the fear, I think the reason why, and I'm not, they come from a place of, if this is true, the repercussions are huge. Someone can die. Someone can eventually be killed. If this
True.
person's released, like, so that is I think the place. And I'm trying, like, I oftentimes try to give people the benefit of the doubt, try to think of where they're coming from. Although I might not agree, I still see where they're coming from. And I think that's where they're operating from, where it's like, okay, if this person is really, which has happened, you know, this person's released back into the community, which, I mean, if it's a domestic battery and it's a misdemeanor, they're going to get out and like max, they can only be held for a year.
Right.
So they're going to get out back into the community anyways. But I think that they're like, okay, how can we separate the two or the situation for as long as possible, like while we have it in our control? Because if somebody looks into it and they're released and something happens later, they're going to come back and say, oh, it was this judge.
And that is why when people say, well, why do the police in Florida act the way they do with domestic? That is why.
Yeah.
They are preventing the Gabby Petitos. They want to prevent the most extreme case from happening under their watch. They don't want to be the one that turns on the news and says, oh, I actually I stopped them in a car and saw there was a sign of domestic abuse, but I let it go. Or we got a call about domestic abuse, but we reported and saw it was kind of like BS and let it go. Like, no. And I do not blame law enforcement for the way they handle. I don't. For a lot of the domestic cases, I don't, because if they get there and it is so clear that the only allegation is like yelling, or it was a neighbor calling in about some yelling, I've had that, and that's bullshit. But if you have something where it's like, the caller or one of the parties is saying, hey, this person just punched me in the face, this person did this, like, what, their hands are tied.
I really feel like there should be more training for police to be able to diffuse and detect. Like, first of all, they need to, aside from all this, like, detect mental health issues, because sometimes that comes into play.
Yeah, of course.
Which they don't do at all. They're just like, oh, you're acting crazy, and they'll arrest you. Quotes around crazy if you're listening, not watching. But that is one issue. Also, being able to detect actual domestic violence victims, and then having another remedy. Like, maybe these people just need to be separated and not arrest anybody. You know what I mean? Like, maybe there's an avenue that we can make, not we as in us two, someone in the legislator, but that's how.
But I think about it but you also have to think like the officer that's on patrol that night that gets a call to go out to some apartment and says, he gets there and he thinks, oh, maybe it's on the fence. Okay, you guys just go your separate ways. And he leaves. And 2 hours later, the guy comes back and shoots and kills his wife.
But also consider
it's like,
consider
where's
the allegations. Yes, I agree. Yeah. But like, if the allegation's a push, like, really? I'm sorry, but like, really?
If I understand, I think it's a difficult. I think as much as we don't, that's a difficult position to be in for law enforcement. I think more so than, I'm not one that's going to sit and give credit and at every time for every perfect investigation. But I think the bottom line is when you're dealing with those types of situations, domestic specifically, not just batteries, but domestic specifically, you don't want to be the one that made the call that was
too lenient
when it could have went the other way.
Yeah.
Right.
For sure.
And I think the judge in the domestic cases is like that. That's probably their perspective as well. But they have a big onus of being able to smell the bullshit.
Yeah, which is, I think, important when it comes into play with like stand your grounds, because they're the ones that make stand your ground. For people who don't know, is when you have a self-defense case and you file a motion to dismiss to get the case dismissed, and it's by clear and convincing evidence on the state to show. I think it's, now I'm blanking out. It's for the defense to show that it was self-defense.
Correct.
And then the state has to show that it wasn't. So, I think filing the motion is good enough, and there's case law to say that. It's good enough to shift the burden to the state to disprove that it's a self-defense case. So it's that opportunity for judges, I think, when it comes to self-defense cases. Obviously, when it comes to it didn't happen, that's for the jury to decide. But when it comes to self-defense cases, that's when the judge can really decide. And that's what, like the example you gave with like somebody trying to leave the house at the door, and somebody ends up touching the other person or pushing the other person, whatever it is, that could be a stand your ground. You know what I mean? Like, I was trying to get out and they were pushing me. I was
for sure. Whatever it is.
But you know, that's when the judges really need to, I think, do what they need to do. I was in domestic violence while I was a public defender. I was in that division during COVID, actually. And that is a trial heavy division because it's a lot of he said, she said, and in county court specifically. And trials were suspended. I was like, you know what? Stand your ground. Let me go through my caseload. My caseload went up to 400 during COVID because we couldn't close cases out. Like the ones that were trial cases were at a standstill.
Yeah.
Clients were sitting
Everything was in a logjam.
Yeah. Clients were sitting in custody waiting to get out. And bonds were being denied for the reason that we're explaining, you know, and they also sometimes don't have a place to go. You have to show, hey, you know, they have another place to go. They're not going to go back to the house, whatever it is. Went through my caseload. I filed stand your grounds on every case that was like had a legitimate stand your ground argument, which was a lot for a PD caseload, 400 cases. You know what I mean? That was a good amount. And you know, the average caseload was not 400. It was like 120, which is still, it's a lot, but in county court, it's manageable, I think. But listen, I don't think it was me. I got a good amount dismissed. Like 30 over the case, like probably like 4 months.
Of domestic cases that you
filed the stand your ground.
Yeah.
And like that was because the judge smelt the bullshit.
Yeah.
Or saw that it was on the line. It's not like you're when you think of domestic violence, this person coming at me to being this abuser.
Right.
You know what I mean? Like when you show that and the judge does what they're supposed to do, it's like, so like, it's like, I feel like that's like really like true justice in my opinion. But I also think justice is relative, and I don't think it's like this is another conversation for another topic, but I think people want to talk about justice as an objective thing, but I really do think it's a subjective.
Your wedding begins here. You've found your person. Now find your perfect place. Welcome to Marin County, where your love story meets its perfect setting. Exchange vows beneath ancient redwoods on a sun-kissed beach or overlooking the sparkling San Francisco Bay. Whether you're planning an intimate elopement or a grand affair, Marin offers the space and the spirit to make your wedding uniquely yours. Discover where forever begins at visitmarin.org and explore the weddings page for details.
Thing, because justice for a victim.
Resolving a case is the fundamental question that we get asked sometimes is, how many cases have you won? What do you know? The answer is based on how you define what winning a case looks like. Does winning a case look like a dismissal outright? Does winning a case look like you're not going to jail? Yeah. What does winning a case look like? And that is a very subjective thing. I think after doing and handling thousands and thousands of cases, I can say I have a pretty objective view of what a win looks like in a criminal case for either party.
Yeah.
But ultimately, you're exactly right. That's a completely subjective thing.
Yeah. And justice for a victim is not the same as justice for a defendant, you know, or one of our clients. So that's like, I really do think it's like in the eye of the person that is viewing it. So, yeah. When also, like, speaking of no contact orders, sometimes restraining orders come about from.
Yeah. I handle a lot of injunctions in Florida. We don't have restraining orders. We have injunctions, which is the same concept. But oftentimes the domestic violence injunctions go hand in hand with criminal cases.
Yeah. And, you know, that's always like comes into play when they're seeking or the alleged victim who is a petitioner in an injunction is seeking an injunction against the respondent who is the defendant in the case, the criminal case. And they are, you know, giving statements, and that becomes evidence in the criminal case. So like there's so many different ways that there's like overlap, and then that's another way that someone ends up like homeless, you know?
Yeah.
So it really does kind of just upend, you know, someone's life in just a moment.
I think there's a double-edged sword to having I think Marsy's Law has a double-edged sword, and I think if it is used or really I should say, if it is abused by somebody that knows a little bit about this, the way that the system works, it can have a detrimental effect on somebody's life.
Yeah.
And it can be effective.
Yeah.
Because if you know that somebody's going to get arrested if the police get called, if you know that a no contact order is going to be put in place as long as you show up at court for the bond hearing and say, I'm afraid of this person, I don't want them to come home, the judge is never going to let them back home.
Yeah, 100%.
And that could be a year that a case is pending and this person's not allowed home. All for something that was a petty issue to begin with. That's where you see an abuse of that Marsy's Law. And you see, that's where you really hope that you have prosecutors and judges that are willing to say, okay, well, we understand that as a victim, as a genuine victim, you have these rights.
Right.
But you individual are not presenting as a
credible
victim.
witness.
You are not. You seem to be using this to your advantage and using, this shield, if you will, as a sword.
Yeah, it's like a weapon. Really,
Right.
They're weaponizing the criminal justice system.
Correct.
And Marsy's Law also gives protection in terms of their identity. Like they can stay. Basically, I've never actually had to challenge this because there's a confrontation clause where every person who's accused of a crime has the right to confront their witness or their accuser. And when it comes to domestic violence, obviously I've had the police reports where it's like redacted with their names, but ultimately when I get the list, the witness list or whatever,
They have to give you the information.
right. And I've never had an instance where a prosecutor was like, I'm not giving you the victim's information.
Right, because ultimately, as an officer of the court, it's supposed to get to the point where if you have that information, you're not doing anything nefarious with that or malicious with that information. So at some point, the keeping all of the victim's information confidential and the right of confronting and cross-examining the witnesses.
I really think it comes
Comes
from
into
the reason why I think, not to give prosecutors any ideas, but I think the reason why is because Marsy's Law came out in 2018. Confrontation clause has been around for decades. And it is kind of new though. It like happened, I think in the 60s or something. I don't really remember actually. Don't quote me on that. But I know that it was a newer thing. But still, Marsy's Law is way newer, 2018. And I think it just came, like it was a practice to turn over everything as required. But I wonder how it would play out in the courtroom or in litigation if a prosecutor is like, no, they want to remain confidential and they have the right to. How would that play out for trial purposes? Because how are you going to balance the constitutional rights of the person who's accused and balance the now constitutional right of a victim in a case? Which to me, I was like, when I found out about Marsy's Law, I was like, how? Like it just, to me, it doesn't make full sense. Like some of it does, where it's like, okay, they have a right to be heard, they have a right to know about the proceedings, all those things. Fine, fair. But the confidentiality part, I'm like, make that make sense, because this person prosecutors have a Brady obligation. They have to turn, like, you have to turn everything over as a prosecutor. There's nothing you can not turn over, whereas the defense, if I have a conversation with my client sends me an email, like that stuff is all private. Like prosecutor does not get access to that information. So how do you balance the rights of the person who's accused to be able to confront the person who's making allegations against them, and then the rights of that person? Like there's
protected.
There's two people with constitutional rights in this case, and it's not person versus person. It's state of Florida or government versus person.
Correct.
So I think
that's a really good question.
Yeah, I mean, I haven't seen it play out, thankfully. Not to give anybody ideas, but it is something that I've thought about. I'm like, and then it doesn't make sense. Why are you redacting police reports when I'm going to get a witness list in 2 seconds? But whatever.
Well, we'll see. About a week after this episode drops, we'll have that problem. So we'll be dealing with it.
God forbid. I'll be like, fuck, that's my fault.
Yeah, right. Yeah. Oh, that's my bad. And then we'll come back for another episode of Come Back with a Warrant, and we'll say, hey, to all the prosecutors listening.
Yeah, and then I'll have to draft the reform bill for Marsy's Law.
Oh, wow.
To allow for some transparency and safety for them to, honor our confrontation clause rights as defense counsel and defendants in cases. Moving on to the next part of this episode is the plea deal trap. And this kind of goes into what you were saying about not every win looks the same in every case. Kind of.
Correct.
Is that what you're saying? I
Yeah,
don't wanna
and
take
not
words
a
out of your
win.
mouth.
Yeah, a
Like-
win is in the criminal law world. A win is in the eye of the beholder.
Yeah.
And it is in the, what is a win for one person is not necessarily a win for another.
Yes.
Head to Safeway this week and enjoy these amazing deals. Clip coupons from the weekly mailer or download them from the Safeway app to breeze through checkout. Post cereal, Quaker cereal, or instant oatmeal, Pop-Tarts, Rice Krispies treats, Welch's fruit snacks, Nature Valley, Nutri-Grain, or Quaker Chewy bars, and General Mills cereal, various sizes and varieties, all just $1.99 each when you buy 4. Earn 4 times points on Juicy Sumo citrus fruit, just $2.99 per pound. Visit Safeway.com for more details. See you in the aisles.
You will meet clients that expect a win to be a dismissal, and that you will, meet people that is their only definition of a win is a dismissal. The truth is that a win is what we were able to mitigate and what we are able to get given the circumstances. A win in a DUI could very well be a DUI conviction, but with no jail. Mitigate with, less probation terms.
Yeah.
It's a question that I get all the time, how many cases you win, how many cases you lose.
Yeah.
You can't answer that question unless you're the one that's in the position. I have clients that are very happy as long as they're not going to jail. So even if that means a guilty plea, they'll tell me, hey, I don't care about, conviction, probation, anything like that. I just don't want to go to jail. Well, the win for them is just not going to jail. But that still could be a conviction.
Yeah. I think it also comes into play, like what evidence is there against them, and how, if the state can prove it, how they can prove it.
Right.
And then, their history. Sometimes that comes into play, like their score sheet. You're scoring. Score sheets in Florida are the sentencing guidelines in felony cases for people who don't know, and it tells you the lowest permissible sentence in months that you can serve. And sometimes just based off your history and the charges that you are being charged with, even if you are NG all the way, you really have to consider the score sheet, because if you go to trial and you lose, obviously the score sheet is not the only thing. You have to consider the evidence and what the state will present. But if you lose, the judge cannot go below that lowest permissible months in on that score sheet, or your minimum mandatory associated with whatever charges you have. If you're, if you have a minimum mandatory associated with your charges. So there's so many different aspects to think about. And when you are evaluating a case, sometimes I'm telling my clients that this is a win. Like, I have to tell them, like, this is a win. Like, I'm sorry you feel
in your
like,
best interest.
yeah,
It's a win.
yeah, like you're not, it's not the best outcome in your mind because you wanted to get a not guilty or get it dismissed, but this outcome is a good outcome considering all of these circumstances, unless you want to take the risk, and we do it, and that's their decision. And I'm always down to do it. You know what I mean? But at the end of the day, I'm always going to give my recommendation. Like, I don't know if this is a good idea, or I think this is a good idea. So there's so many different aspects, especially considering the maximum sentencing and the minimum sentencing. Usually, yes, the maximum sentencing comes into a part of the conversation, but it doesn't really control the conversation. I think more so like the score sheet in felony cases, at least. Score sheet, who your judge is. Obviously, there are ways to depart from the score sheet. Downward departure is a way.
Sure.
But there are certain ways to depart. You can't depart for any reason. And at the end of the day, the judge is the one who's deciding that. So that comes into play as well. Like, does this judge usually do this? Will this judge do this? Does this judge sometimes, you really study patterns of people and judges to know what's expecting in that case, like what's to come in that case. So
And to know what a win looks like in that courtroom.
yeah.
Know the judge, know what the judge is going to do, what they're likely to do on a case. I had a case where a client of mine scored 41 years in prison.
Yeah.
And he was looking at, if you stacked all of the charges against each other, it was like 5 life sentences.
Yeah.
And if the judge were to sentence him just by him pleading guilty, she had to start at 41 years. I was able to negotiate a plea deal for him for 20 years. That's 20 years, day for day that he's going to prison. But when you look at 20 years versus 41 years or versus a 5 life sentence, it's a win and it's a no-brainer. But to the outside perspective, a win at 20 years, it's insane.
Yeah.
But that's the truth. And that's, where it comes down to, well, as far as I'm concerned, it was a huge achievement to get the offer down that low. And my client, who did accept the offer and is serving the 20 years, really believed that was a win. And that is because that is a win. It was a win. It was the cases were indefensible. It was a win. And that's, every single case is different. And your plea deals that you fall into, or this plea deal, trap that we're talking about, it's not necessarily a loss just because you're walking out of it with a plea.
Yeah.
90% of criminal cases, I think it's more than 90% of criminal cases result in plea deals.
Yeah.
That's not because criminal defense attorneys are out there and they're just resolving all their cases or they're quote unquote plea lawyers and they just are pleading out all their cases. It's genuinely in the best interest of the client to resolve the case that way. And it is a win for that client.
Yeah, especially because the prosecutors are the only ones in the courtroom that have the power and discretion to be able to depart from the score sheet or the guidelines as much as they want, technically, if they obviously within reason because they're doing their job. But if there's a victim associated with it, and then that comes into play as well with Marsy's Law, not just with domestic violence, but it is something that is to consider. Like, that is something I always tell my clients, the judge can't do that. Sorry, the judge cannot do that. It's the prosecutor. And if you want to get this result, we're going to have to show this prosecutor that you should get this result. So oftentimes mitigation binders, whatever it is, whatever we need to gather to show them that you should get this result and they should depart from the score sheet. And usually, I don't want to say usually, sometimes, oftentimes, the offer is different from this less than the score. But it's a matter of what, in your situation, 40 years, it depends how old you are too. Like if you're 6 years old and you score 41 years, that's life.
He was 26.
Exactly. So then 26, 20-year-old, he'll get out. He'll be older. It sucks.
But he's going to get to see his kids. He's going to get to live again out of custody.
Yeah, and oftentimes these are the realities of our conversations with our clients. Like we actually have to break it down to them like this sometimes. Well,
yeah, it's a tough conversation.
Yeah.
Yeah, it's a really hard conversation to try to explain why that's the best scenario.
Yeah.
But that's part of the gig, and that's part of, what we do.
Yeah. And, you also have to think about what could happen at trial as a result versus what's in front of you.
Sure.
And we can never guarantee any outcome. Just like I always tell my clients, even though I'm confident, I'm telling you I'm confident, that doesn't mean that this is what's going to happen. I've been confident so many times, and at the end of the day, it hasn't been the result that I was confident in. You know what I mean? Mm-hmm. So that's to say that you need to, I'm not the only player here. There's so many different aspects and moving parts to this case that we need to consider, and you have to take that into consideration when you're making a decision as big as this. So I think that when people think about pleas or convictions or whatever it is, oftentimes people who are innocent do plead guilty to things and do take pleas that they don't necessarily want to or desire for, but they do it because it is in their best interest.
Yeah.
So, and that's just a reality of what we do. And oftentimes it's humanizing our client for the purpose of getting the best plea possible. And that's what the way I approach every case is I'm going to go gung ho, prepare for trial. At the same time, prepare the best mitigation binder I can or packet, whatever, send it to the state government and see what the best offer I can get, show my client, okay, this is the evidence against you. You can go to trial. This is the best plea offer I can get you. Make your decision based off of this is what's in front of you. You can take it. This is the max if you go to trial. This is the best case scenario if you go to trial. What do you want to do? You know? And that's really how I approach every single case.
Give them the options. You're just giving them the best possible options given the scenario.
Yeah. And I do because sometimes when you prepare, and the reason why I prepare for trial from the beginning is because sometimes the faulty parts of the case, when you're preparing for trial, whether like it's for depots or whatever it is that you're doing, you can oftentimes show the state. Sometimes it shows that your case is shit and you should definitely not go to trial, which is a still kind of a win, I guess, if you think about it, because you're confirming this is not going to go well for your client. But then sometimes you can show like, this witness isn't reliable. Like, you're really going to believe this witness that like backtracked in their words or like they recanted or whatever. Obviously, that doesn't always get rid of the case completely, but it does help the case. You know, I think it does. I think the prosecutors will usually consider that, be like, okay, well, I guess unless there's some sort of reason they think of that's like, oh, they recanted for this reason, whatever. But I think that, you know, usually preparing for trial can help you in the other department too. So all that to say, plea deals are very much so something that we have to do as a part of our job and consider when it comes to functioning as defense attorneys. You know, sometimes it sucks. Like when my client took the plea for the misdemeanor and I was like, let's just try this case again. Why are you taking this plea? For the felony,
but it's
my first felony trial.
Is a lot better,
exactly,
guaranteed outcome than potentially losing a trial on a felony.
Yeah, and you know that comes down to our clients feeling pressure, understanding that somebody did believe the alleged victim, whatever the case is. But yeah, I think that's all we have.
I think that is everything for today's episode of Come Back with a Warrant.
Yeah.
Thank you very much for being back with me.
Yes,
as
thank
always.
you. And make sure you follow, like, subscribe on all channels on YouTube, Instagram, and TikTok. We are on all platforms. Come back with a warrant.pod and join us for next time.
And if you don't like that, come back with a warrant.
This episode is brought to you by Progressive. Most of you aren't just listening right now. You're driving, cleaning, and even exercising. But what if you could be saving money by switching to Progressive? Drivers who save by switching save nearly $750 on average. And auto customers qualify for an average of 7 discounts. Multitask right now. Quote today at Progressive.com. Progressive Casualty Insurance Company and Affiliates. National average 12-month savings of $744 by new customers surveyed who saved with Progressive between June 2022 and May 2023. Potential savings will vary. Discounts not available in all states and situations.